We're good to go. Yes. I'll repeat that. We're good to go. Thank you, thank you. So it is indeed my pleasure and honor to introduce our keynote speaker this afternoon, Dr. Emma Cunliffe. She is a renowned scholar and a professor in the Allard School of Law at UBC. And we're honored to have her present on this occasion on a topic of relevance to the FREDA mandate. And a little background first, Dr. Cunliffe was the director of the research and policy for the final report of the Nova Scotia Mass Casualty Commission entitled Turning the Tide Together, which was a joint federal and Nova Scotia report triggered by the mass casualties in 2020. And she has presented the results and recommendations of that commission's report in venues across Canada many times. Today, Dr. Cunliffe will be presenting on related interests on studies of how courts decide the facts of contested cases. She's especially interested in expert evidence, the operation of implicit bias and legal processes regarding gendered and racialized violence, especially those regarding Indigenous peoples. She's particularly interested in investigating whether expert knowledge, such as forensic reports, psychiatric testing, can operate as a kind of Trojan horse by which discriminatory knowledge and beliefs reinforce implicit and structural biases within the legal system. She also studies examples of legal processes in which discriminatory beliefs are successfully countered. And her work around what has been successful is of relevance for both community practitioners who may have to make decisions themselves in such situations, such as parental assessors, as well as legal practitioners. And I believe that the focus will be more on the latter in terms of what can be successful. And we'll have a conversation about that as well. So this focus is quite consistent with the FREDA Center's mandate, along with the other centers forming the Alliance of Centers. And one final point, it's also appropriate to note that Professor Cunliffe won a Courage in Law Award from the Indigenous Legal Students Association in 2016, plus receiving several other awards and fellowship for her work. So please join me in welcoming Professor Emma Cunliffe.
Thank you so much, Margaret, for that very generous introduction. And hi, everybody. It's so lovely to see you all today. It's my very great honor to be invited to speak today. And I want to begin by saying that I found the task of preparing my remarks for today quite daunting. And the reason for that is there are so many people in this room whose work I follow and admire and aspire to, and I hope you'll see that reflected in what I have to say. I'd like to begin in a good way by thanking Elder George for welcoming us today. And by acknowledging that we are indeed gathered on the traditional, ancestral and unceded territories of the Musqueam, Tsleil-Waututh and Squamish peoples today. This image, this beautiful image, which was a photograph taken by Melody Charlie, will be recognised by those from Rise Women's Legal Clinic. It's the front cover of their wonderful work on decolonising family law. I want to acknowledge that it's not possible to talk about expertise in the context of family law and child protection proceedings without acknowledging the leadership that has been offered by Indigenous communities, the knowledge that's been generated as a consequence, as a direct consequence of the continuing trauma and effects of colonisation. And That work has pushed the colonial legal system to reconsider some of its priors. It has, we all have more work to do. And one of the things I found particularly difficult as I was thinking about where to begin today. And it's a question I'll return to at the end, and I hope we can discuss together. I've left a lot of time for discussion, recognising the wisdom that's in this room. Is the conundrum that we face between making the existing system better, recognising that it will continue to operate and it will continue to do harms, and building a very different approach to keeping children and women safe from violence. I think that's a conundrum each of you face in your day-to-day work as well. While I've been invited to, and I will fulfill my brief, talk about the limits of expertise and questions of myths and stereotype within a predominantly adversarial colonial legal context, I think it's tremendously important to begin by acknowledging the narrowness of that frame and the possibilities of doing this work in a profoundly different way if we had a little more resources, a little more shared political will outside this room to approach things in that way. And I think that that's a possibility we need to hold open even as we're talking about improving the existing system. I also want to begin by celebrating 30 years of the FREDA Centre. Feminist research, education, development and action. The FREDA Centre has a place which is very close to my heart for a couple of reasons, and Margaret knows about both of them, I believe. The first, Margaret alluded to the work I did with the Mass Casualty Commission, and it was my privilege to serve as Director of Research and Policy for the Commission. There were some respects in which the work that we did with respect to intimate partner violence and gender-based violence felt like an opportunity to begin to address the unfulfilled promise of the fact that there was never a commission after the Montreal massacre. And so 30 years later, to have the opportunity to think about what our approaches to intimate partner violence and gender-based violence might look like if we centred the experience of women and gender diverse people, if we took the expertise of the women's anti-violence sector more seriously, if we focused on prevention rather than on intervention after violence has already taken place. The second reason why FREDA has a very, so FREDA, together with its sister centres across Canada, is one of the truly wonderful things that came from the dark days in Montreal in 1992. And the work that FREDA has produced in the 30 years of its existence and the work that sister associations have produced in other universities and community settings across Canada since then is the work we were building on in the Mass Casualty Commission. I just want to acknowledge that our capacity to do the work we did was possible because FREDA existed and had done the work that it did. So I want to thank you for that. My second connection with FREDA is that when I was a PhD student at UBC working with Susan Boyd and others, and I have to say I've been pulling hard on my work with Susan as I prepared for today's talk and her wonderful work on the ideology of motherhood and the ways in which courts approach questions of best interests of the child and good parenting. I very often worked with Angela Cameron in the SFU Harbour Centre in the FREDA offices. And we wrote large portions of our PhD sitting side by side in that space. And I'm so grateful to FREDA. I had no particular formal affiliation, but you offered me a safe space in which I could do feminist work. And so I thank you for that as well. So I was just delighted to receive the invitation to speak today. I've already alluded to the Montreal massacre, as has Margaret, and I want to acknowledge and remember that this is where this work starts. In a very deep sense. Of course, there was feminist work on violence against women before the Montreal massacre. Of course, it would have continued regardless of the Montreal massacre. But I think a key point and a key reason to gesture towards what happened in Montreal that day when women were targeted for having the temerity to seek an education in the sciences is the very deep connections that exist between the mass violence that so shocks the conscience of our community when it takes place. The Montreal massacre is an example. The April 2020 mass casualty in Nova Scotia was another. But what we often lose in the discussions about such mass violence is the very close and very direct connection between those forms of violence and the more quotidian, often more hidden, day-to-day experience of gender-based violence and intimate partner violence that we as a collective society outside of this room are so bad at recognizing, at taking seriously, and at countering. And so it is the mass violence that tends to get a lot of the attention. But certainly the work of FREDA, I think, is very true to the spirit. And the Mass Casualty Commission seeks to really centre that it comes from the everyday acceptance of gender-based and intimate partner violence and from our failures to understand and to counter that violence. All right, so what am I going to talk about today? I'm conscious that I'm speaking to a room of people, some of whom are lawyers, judges and former judges, some of whom are not. So I've tried not to make the talk too focused on legal principles, but I will spend a little bit of time talking about some key principles as they're understood in contemporary Canadian law, to sort of put us on a footing from which we can have, I think, a different kind of conversation. I hope a different kind of conversation. I'll then turn to my own work on the interplay of expert evidence, myths and stereotypes. My own focus has been largely on contested criminal proceedings, but again, I'm going to make the argument that there are really strong common threads between what I observe in the criminal cases that I study and the family law work that, for example, Rise Women's Legal Clinic, West Coast Leaf and FREDA have been doing in various ways over time. And I should mention actually at this juncture that in preparing for this work, I did a lot of reading, which was really lovely to have the opportunity to step back into some of the work that I hadn't sort of looked closely at since really the time I was doing my comps for my PhD. And in the hopes that it would be helpful, I prepared a bit of a bibliography of some of the resources that I found. And I've focused particularly on open access resources, so things that are not behind a paywall. And I've shared that with Sarah and Margaret in the hopes that it can be shared with you, because I did want to offer something of value. So hopefully that will prove useful to you. I'll then turn at the third part of my talk to discussing specifically some of the key issues, as I understand it from the literature, that have arisen in family law and child protection. And here I really do want to acknowledge the extent to which I'm relying on the work of Donna and Margaret, of Rise Women's Legal Clinic, of West Coast Leaf, and of others in this room who have done a tremendous amount of work to bring these issues to the attention of courts and to prepare reports and research on them. And lastly, I want to open it up and to draw on the wisdom and expertise that's here in this room to take this opportunity being gathered together to talk about some of the questions that we might share, that we might face in different ways. Okay, so let's begin with some key principles. The Canadian case law on myths and stereotypes is, I'll say, from my vantage as somebody who sort of follows the case law quite closely in a number of jurisdictions, perhaps one of Canada's greatest feminist legal achievements. It is also widely misunderstood within the legal profession. So as so many feminist achievements are. What I mean by that is that to a very large extent, driven by the efforts of feminist intervener organisations who, for decades, have presented careful arguments about the demands of substantive equality and the challenges of fact-finding, until finally they got some judges who listened, and then those judges too have made a huge intellectual contribution. What we have in Canada is a remarkably strong line of case law, which identifies the significance of the operation of false ideas about marginalised litigants. To a large extent, one of the limitations of this line of case law is that to a large extent it has focused on sexual assault cases. So in the criminal context, and that becomes relevant in a moment when I turn to the recent decision of Kruk. But what successive feminist judges have developed with the assistance of feminist interveners, most of whom were not paid for their work, is a line of case law that identifies that it is invidious to substantive equality, so it takes away from the equal protection and benefit of the law, for a court to make a decision about facts in an area which has historically been subject to historical disadvantage of women or other groups, on the basis of myths and stereotypes. Now, myths and stereotypes tends to be used as a compendious term with very little definition by the Supreme Court of Canada and by other judges. And so I've given you here kind of in a sense, the best of kind of what existed up to the decision of Kruk, which was handed down on International Women's Day, no mistake, I suspect, which I'll turn to in a moment. So in Quebec versus A, which is a Section 15 equality case, Justice Abella defined a stereotype as a disadvantaging attitude that attributes characteristics to members of a group regardless of their actual capacities. Now, there's an important distinction between stereotypes, as the Supreme Court of Canada uses it, and that word as, for example, psychologists use it. So frequently in psychology research, stereotypes are talked about as a heuristic mechanism that our brains use in order to be able to navigate the world with some degree of cognitive ease. So psychologists tend to use the word stereotype in a fairly neutral sense. It can be right or it can be wrong, but it sort of broadly just means a cognitive shorthand. In law, the word stereotype has this intrinsically prejudicial dimension to it. So it's treating somebody disadvantageously based on some idea about them. A classic example is the notion that women lie about having been sexually assaulted. So by virtue of being a woman, by virtue of having made a complaint of sexual assault, you are treated as being less likely to be truthful than if you occupied a different subject identity. A myth is basically not defined at all in the case law. Jennifer Koshan, in her 2023 article, Challenging Myths and Stereotypes, which is excellent, offers the simple and I think accurate definition. It's a commonly believed but false idea. So the idea that women commonly lie about being sexually assaulted is a commonly believed but false idea. Another useful thing that Jennifer Koshan does in the 2023 article is pull apart two different kinds of myths and stereotypes that she says, and I agree with her, have tended to be sort of lumped together in the case law. And there may well be other kinds of ways in which myths and stereotypes can operate, but I think these two categories are very useful to bear in mind. The first is those that operate to say something about survivors' credibility. So women lie is an example of a myth which is about credibility. Somebody should not be believed, or should be less likely to be believed, or we should be less ready to believe them because of something about their subject identity that they can't change. The second is those about the nature and harms of certain kinds of crime. And so the article I'm citing from here is an article on domestic violence. So this is ideas about, for example, that children who witness violence but aren't subjected directly to violence aren't adversely affected by the violence. That would be an example of a myth and stereotype which operates with respect to the impacts of the behaviour rather than the truthfulness of the person who's speaking to the behaviour. That's the distinction she's drawing. There have been several authors, some of whom are in the room, who've done tremendous work to bring together and identify and kind of document which myths and stereotypes have been identified by judges, and also to identify which myths and stereotypes have not been identified by judges but have been relied upon by judges in the ways in which they reason in particular cases. So I've put 3 examples of such work up here, including Donna and Margaret's piece, and there are others listed in this list of resources that I'll share with you. It's also important, I think, before we move on to CRUC, to acknowledge the intersectionality of myths and stereotypes. So what I mean by that, and what the literature, including the pieces cited on the slide, say very widely, is that myths and stereotypes will not operate in the same way with respect to, for example, an Indigenous woman who exchanges sexual activity for payment, as they might with respect to a white college student who makes an allegation of sexual assault. It's quite likely that both will be subjected to myths and stereotypes or encounter disbelief, but the nature of that disbelief and how it operates will look quite differently. And so intersectionality is tremendously important in this field. And I will draw your attention, unfortunately, I couldn't find anything open access by Patrine Duhaney, but she's a professor of social work at the University of Calgary who's doing fabulous work on Black women and myths and stereotypes. So there is some work done now in Canada on Blackness and credibility in intimate partner violence and gender-based violence. Unfortunately, and for reasons I'm sure to do with the political economy of academia, at this stage that work is largely not available open access. But if anybody needs that work, tell me, and I'm sure that we could figure out something. Okay, let's turn to the recent decision of R versus CRUC, and this is the Supreme Court of Canada's most recent statement on the operation of the myths and stereotypes case law, and it's a very interesting decision, and it's part of what I had in mind when I said that the legal profession and to a certain extent the judiciary continue to misunderstand the myths and stereotypes doctrine. CRUC, in CRUC, the Supreme Court of Canada was asked to rule on a line of case law which had developed in the BC Court of Appeal and the Ontario Court of Appeal in response to the myths and stereotypes doctrine. So something that will be familiar to all of you feminists in the room happened, which was that a whole lot of judges and courts of appeal decided that since women got the benefit of the myths and stereotypes doctrine in sexual assault, we needed to even the scales for the largely male accused in sexual assault. And I'm sorry, I'm being a little bit facetious here, but not very much. It's pretty close to the truth. And so what they decided to do was to develop a doctrine, which they called the doctrine of common sense generalizations. And so the doctrine of common sense generalizations sought to generalize the myths and stereotypes doctrine to any inference that was drawn by a trial judge about common sense behaviour from the testimony given by the witnesses at a sexual assault trial. So, for example, some of the examples that are discussed in the CRUC case include how an accused person might behave differently if they have just knowingly had sexual activity without consent with somebody than if they believe that the activity was consensual. And BC Court of Appeal and Ontario Court of Appeal had essentially developed a common law doctrine that said that the courts of appeal could review the trial judge's reasoning in that regard based on what in technical legal terms is called a standard of correctness. For purposes of today's discussion, I'm going to say that standard of correctness operated as if the Court of Appeal disagreed, they stepped in. And what this meant was that convictions obtained at trial were being overturned by courts of appeal and turned into acquittals on the basis that without having seen all the witnesses or had an opportunity to kind of evaluate in that sense, the Court of Appeal would feel that the trial judge had relied on an impermissible common sense generalization about human behavior. Okay. Now, why this is important, and Justice Sheila Martin's judgment is fabulous, is because in the narrow doctrinal sense, why it matters is because it was a change to the standard of appellate review. So it meant that it was easier for courts of appeal to turn a conviction on a sexual assault case into an acquittal. So that's obviously probably not a great thing if we look at the overall conviction rates for sexual assault cases. Why it mattered from a perspective of where the legal culture is as of 2024 and its understanding of the myths and stereotypes doctrine is it suggested a widespread misunderstanding among our intermediate appeal courts, so there's a very senior courts, about why the myths and stereotypes doctrine exists. It was a lack of recognition by the Ontario Court of Appeal and the BC Court of Appeal that there's a historical disadvantage, a historical lack of credibility that's given to women complainants, which was being ameliorated as a matter of substantive equality. So it wasn't about lifting up the credibility of women complainants above that of male accused. It was about trying to get people up to par. That misunderstanding is tremendously important, I want to suggest to you, as a matter of legal culture. The fact that the courts of appeal didn't understand and appreciate the significance of that suggests we've still got work to do. So here in the paragraph I've got on the slide, Justice Martin identifies this historical purpose of the myths and stereotypes doctrine. And she goes on and identifies the historical barriers and the historical legal rules about belief of a sexual assault complainant, which the myths and stereotypes doctrine is designed to counter. Now, this is all good, but it presents potentially a challenge with respect to a recent win that Rise Women's Legal Clinic has had, and I'll return to that later. I think we're okay, but I think I do want to sort of flag vulnerability. I'm sure you're already aware of it. Okay, so that's myths and stereotypes. The next principle I want to sort of spend a little bit of time with will be very familiar to those of you in the room who are legally trained. And it's the basic case law about expert evidence. So in Canadian law, in an adversarial colonial legal process, an expert is defined as somebody who's acquired special expertise by virtue of study, knowledge, or experience in a subject that's relevant to the legal proceeding. Okay. So this kind of fairly innocuous definition has been in existence for a long time. It largely persists, even though the case law has kind of, to a certain extent, moved on in other kinds of ways. So the idea of having somebody whose expertise is defined in this way is that that witness gets to do a special thing that other witnesses don't get to do. They get to offer an opinion on the basis of their expertise. So not just to testify to what they saw or experienced or felt, but also to what those things mean. In theory, the admissibility of expert evidence is subject to an admissibility inquiry to evaluate the expert's qualifications and the necessity and reliability of their evidence. And over time, the Supreme Court of Canada has increasingly emphasised that trial judges have what they call a gatekeeper role to ensure that unreliable expert evidence doesn't enter into fact determination. In more recent jurisprudence, they've emphasised that gatekeeper role exists regardless of whether or not a party objects to the admissibility of expert evidence, so it's standalone. And B, that it continues throughout the time when the expert is testifying. So it might well be that an expert appears fine at the outset, but then is invited by counsel to go into something they're not really qualified in. And what the court has said repeatedly at this point is that the trial judge's responsibility is to keep that expert to the limits of their expertise and to the limits of the admissibility of that expert evidence. In practice, however, in criminal law, as is true in family law and child protection, many experts are admitted without this kind of scrutiny. That's possibly particularly true of experts who are introduced at the instance of the state. So, for example, many forensic scientists, many people who are testifying to psychological assessments of various kinds, whether that's in criminal context or in family law contexts, in child protection. It's frequently the case that expert evidence is admitted without this kind of scrutiny that I've just described. And the court's been sort of mixed in its comments on that. Sometimes it says that was the wrong thing to do and the trial judge should have done differently. Other times it said, well, we couldn't really get it all done if we stopped every time to review admissibility, so there are times when that's fine. And that has obviously left trial judges and trial lawyers occasionally uncertain about the parameters of the capacity, whether an active challenge is needed, whether the proponent of the evidence always has to prove admissibility. These are questions that to a certain extent are a bit shifty in terms of the kind of case law. Now, I just want to pause here and observe that the Canadian legal conception of expertise has been applied in a way that reproduces Western and Eurocentric notions of scientific authority and independence. So if one looks, for example, to cases where an Indigenous litigant has sought to bring information from an academic or somebody like Senator Kim Pate in one example, who's worked closely with that community, it's frequently the case that that proposed expert witness draws a challenge on the basis that they're not sufficiently independent of the community or of the litigant to be able to speak with the authority and independence that an expert is expected to have. And I just want to observe that that is a very Western idea of what scientific authority looks like. And it's one that disadvantages anthropologists who work closely in community, for example, social workers who have close relationships with the Indigenous communities that they're working in. And that question has not been well surfaced within the case law, I would say. So there is this case of Heimbecker in the Saskatchewan courts, which didn't get appealed for good strategic reasons, but which is kind of quite troubling in the way in which it uses those ideas around Senator Kim Pate's expertise. It has been much more thoughtfully applied actually in the BC Human Rights Tribunal. So there's some good decisions coming out of the BC Human Rights Tribunal about the nature of expertise in that particular context. In my own research, I tend to focus on contested criminal cases, as Margaret said, and there's sort of two major groups of work that I've done. For many years, I've had a focus on child homicide cases in which parents or caregivers have been accused of killing children in their care. I'm particularly interested in those cases where the cause of death is in some way contested or contestable. So, for example, cases where shaking is alleged are commonly fit this kind of pattern. So it's commonly the case in a shaking case that either the caregiver says, I didn't observe anything that could cause the head injury that we now see. Or alternatively, for example, a toddler tripped, fell down the stairs. And the question is whether that can fairly explain the head injuries that have been observed. The three dot points I've given you in Ontario in the late 2010s, there was a recognition of a pattern of wrongful convictions and wrongful accusations against parents and caregivers. Often these cases are called the Smith cases, naming Charles Smith, who was a pediatric forensic pathologist who was not properly qualified to do the work that he was doing. and whose name is particularly associated with those cases. I tend to call them the Ontario cases because I think that the Gouge report makes it very clear that it was a system failing that allowed him to do the work he did for as many years as he did. And that it wasn't only Charles Smith, it was others around him who were problematic. I also did a SSHRC-funded Canadian child homicide project after Gouge. I was interested in looking to other jurisdictions to see if the lessons of the Gouge report had been picked up and applied in courts in other jurisdictions. I found that it was still the case that forensic pathologists were giving evidence of highly contestable reliability. And frequently that evidence was not contested by legally aided defendants. And of course, there's a significant question about resources and access to expertise that plays into that. And finally, I've worked on wrongful convictions in both Australia and England. Now, in this space of wrongful convictions and questionable convictions for child homicide cases, there's a disproportionate representation of Indigenous, Black and poor families. And so in this, it is like child protection, it is like family law. In these cases, and again, I'm going to suggest to you that this is like family law and child protection, expert evidence and behavioural evidence work together to construct narratives of guilt and of culpable parenting. So we, in these cases, in the Gouge cases and in the post-Gouge cases, we see the Crown adopting a twofold strategy. One is the medical evidence that says, this is an implausible head injury given the explanation offered by the caregiver. And the second is to bring evidence of other failings in caregiving, other failings in parenting. What my research shows consistently, including persisting after Gouge, is that much of the expert evidence our courts hear has never been subjected to validity testing or to other independent assessments of the expert's capacity to reliably assist the court. And that remains true today. Many forms of expert opinion evidence are susceptible to the operation of myths and stereotypes. So if we come back to the example of the forensic pathologist who testifies, these injuries are inconsistent with the account given by the caregiver, one of the things you might immediately see is that the forensic pathologist needs to know some stuff about the caregiver in order to offer that opinion. And so there is a very significant channel by which biasing information can be shared with expert witnesses as they are in the course of generating their opinions. That's often not recognised by the courts. Courts often fail to recognise when experts are exceeding the limits of their professional expertise. So lawyers frequently invite experts to opine on things which are at the edges or that perhaps they haven't studied closely. Often experts seeking to be helpful will answer those questions. That's a particularly risky area in terms of misleading expert evidence. And so through the sum of these things, what I have concluded, and Margaret's alluded to this, is that expert opinion evidence frequently acts as a Trojan horse, by which myths and stereotypes are smuggled into the legal process in the guise of independent, authoritative expert opinion evidence. Now, this is problematic in two ways. The first is that it's not always observed by the courts that an expert is reasoning on the basis of the very problematic myths and stereotypes that elsewhere they might have excluded from their process. The second, though, is that because the expert opinion evidence is taken to be independent of, for example, the behavioural evidence in the case, it's taken as an independent reinforcement of the behavioural evidence in circumstances where it's often shaped by exactly the same information. I also just wanted to make sure that those of you who are working on these things are aware of the Beeman report of the Mother Risk Commission. The 2018 report on a pattern of wrongful expert evidence which arose in child protection cases in Ontario in the Hospital for Sick Kids, which had also been Charles Smith's institutional home a very small number of years after he had gone. And so I just want to point to this for a couple of reasons. The first is it suggests that institutions aren't very good at learning the lessons when expertise goes wrong. And the second is because the Beeman report has a lot of really, really good, helpful advice about the parameters of expert evidence, and particularly the concerns about myths and stereotypes when dealing with families who are Indigenous, who are poor, who are racialised, and who are under suspicion of causing harm to children. So let's turn to some of the key issues in family law and child protection. I'll speak to these briefly and then I want to sit down and chat. This is where I want to acknowledge the enormous contributions that Donna and Margaret and Rise have made, and thank you for the work that you've done, as well as Jennifer Koshan and Linda Nielsen. There is a wonderful body of information about the shortcomings in expert opinion evidence in family law and child protection, which wasn't true 20 years ago when I was doing my my PhD. So I'm glad to see that now exists. That research, there's a lot of important lessons that emerge from that research. The first is the limitations of these colonial systems of fact determination decision-making that we're still stuck with. That, for example, if you are an Indigenous grandmother seeking for some reason, who requires to have her parenting capacity assessed, and the court-appointed assessor doesn't have an understanding of your Tsleil-Waututh cultural practices and norms, and has been chosen because they're independent of your community, the question of how effectively that person can evaluate your parenting capacity must be up for grabs. It must be. In the very ways in which Western law, Canadian colonial law, requires this arm's length relationship between the expert who can give the opinion and the litigant whose life, or, you know, in the case of children, whose future is at stake. Many Indigenous cultural knowledge systems look at that and find that bewildering. And I have to say I do too, to a large extent. The idea that the decision about the future of a child is best made by somebody who knows little or nothing about the cultural context of the child makes no sense whatsoever. And yet the Western conception of expertise does not include a conception of cultural competence. And that's one of the key, I think, challenges in this space. Questions about who counts as an expert. And so a psychologist who may have little or no experience with the community in question, who may have little or no experience with intimate partner violence and how it manifests, or with trauma, may well be counted as an expert for the purposes of preparing a parenting assessment, but an elder in that Indigenous child's community will not. The challenges of court-appointed assessors, I was shocked, I have to say, and very grateful to Rise to read in a couple of your reports that Section 211 reports are essentially admitted without any scrutiny whatsoever under the admissibility standards. And it's my understanding that that's not what the law itself says. The principles of admissibility of expert evidence should be applied to those Section 211 reports, to parenting assessments, but it's not being. And that was exactly the vulnerability that led to the mother risk scandal. It was the fact that those reports were being admitted without scrutiny. The lack of empirical research, I was really curious. I did a thing on Tippins and Whitman's classic article about the lack of empirical warrant for psychological assessments about 15 years ago. It's a really good article, a classic article. And I was kind of hoping when I came back to this question, when Margaret invited me to speak, to find that those empirical gaps had been filled in. They have not. And again, Rise's work in particular does a really good job of drawing attention to the problems with the lack of empirical research that in any way validates the kinds of recommendations being made in Section 211 reports and similar. The problems of Eurocentrism and other failures of substantive equality, including the failure to recognise expertise in trauma, expertise in intimate partner violence, expertise in gender-based violence, cultural competence, as core to the expert responsibilities is a strong and persistent theme. And finally, problems of cost, timeliness and practicability. And I understand that a private parenting assessment can be literally tens of thousands of dollars. It's clearly well out of the reach of average families. They also take about 18 months on average, which is just not long enough when a kid's growing up. Sorry, not quick enough when a kid's growing up. So I do, if you haven't had an opportunity to read Rise's 2024 submission to the BC Attorney General process reviewing family law in the province at the moment, I recommend it to you heartily. It's just an excellent document. It's extremely comprehensive. in its discussion of the research as it now stands. RISE found that there were no studies that evaluated how children and families fared when the recommendations of the report were implemented or when they weren't. And quite properly points out that this is a fundamental gap in the literature. And it does add insult to injury that this is true when these reports are so expensive. There are gaps in training and expertise. While particular professional organisations, for example, social workers or psychologists, have professional responsibilities, which are not always in keeping with what we might want them to be. The court itself and the legal rules are largely silent on the question of what training and expertise is required for parenting assessors. And that's, again, a huge gap. I've listed a series of gaps in skills. Okay. So now I just want to sort of spend a moment with this decision of KMN versus SZN. And again, this is a case that RISE Women's Legal Clinic took through. And I believe West Coast Leaf intervened in, am I right? Nope, okay. This case was decided literally a few days before CRUC. And it's a very significant win in the family law space. Because it acknowledges the existence of myths and stereotypes in trial judges' reasoning about mothers who make allegations of intimate partner violence or of family violence. In this case, the BC Court of Appeal accepted the mother's argument put by RISE that the father had made a case on the basis of myths and stereotypes about women's complaints. And remitted the case to trial for a retrial with careful attention to the substantive merits of the father's claim. Now, the reason why I sort of signalled from CRUC that there's a slight vulnerability here is because of the ways in which Justice Martin in CRUC expressed herself in the terms of sexual assault law, that myths and stereotypes is about sexual assault law. Now, I think there's a really strong argument, and I think if need be, we'll make that argument, all of us together, that the same analysis which has driven the myths and stereotypes jurisprudence in sexual assault can and should be made in this context. But there is a vulnerability there, I think, partly because of the timing of the two cases. KMN and SZN does talk about the common sense generalisation jurisprudence just a little bit. It doesn't fully base its reasoning on that, but it worries me a bit. In any case, thank you, RISE, and we'll keep fighting that one if we need to. So last of all, I've got some ideas up here, but I'm actually just going to sit down and let people ask questions or talk. Recognising the expertise and the wisdom that we have in this room, and starting with a thank you for all that you've done and all that you do. I just want to talk about some of the ideas that I've shared and some of the ideas that you may have to share with me. Thank you.
I'm good to go. Thank you so much, Emma. That was wonderful, actually. Perfect. And I've been most fortunate in the recent past to have heard you on one other occasion, and it continues to be the case that I've been most impressed with your ability to identify and to distill the true nature of the true challenges of inherent in the myths and stereotypes, which do impact the outcome of the court processes in these cases. And it's true, they distort not only the best interests of the child in the proceedings, but those of the caring abused parent. And I actually will stop at this point. I would like to open now to questions from the floor. Well, yes. Oh, so we have a little mic thing that.
Would you like to sit down and I can turn the camera to the book?
Okay.
I think are there people online? Are there people online, or are we good? No questions so far.
No, here, I'll take it. I take it.
All right.
We'll take it to you.
You know how to turn it on. I'm just going to grab my water, Sarah. Yeah, of course.
Thank you. Oh.
I think it's all right.
Maybe just listen to you. I don't think this is working.
Yes, I think you should just go ahead.
Yeah, just
Okay.
say it.
So,
We're listening.
that was an amazing talk. Thank you for just how you, yeah, distill is a really good word. And the thing that I'm thinking about is we're talking about specifically the vulnerability in cracking KMS and thinking about backlash, which I think is kind of what it is. And I think like what happened with crack, the composite assumptions with the backlash, it was interesting once that decision came down, that some of the social media commentary by some of the defense bar was, did you notice that the Supreme Court of Canada is now quite, has more women judges on it, which is starting to question a bit the legitimacy of the court and why this decision came down. And now that we have KMN, there was some commentary that it was an all-female panel.
Yeah.
And so, but anyway, I was thinking about that and also, and perhaps this is not the forum for it, but I'd be curious to hear more about the vulnerability. We could also talk about that.
Yeah, let's talk about that offline.
Okay.
But it was ever thus, I think. I mean, I'm thinking about Justice LaRue Pay's ordeal after you and Chuck, for instance. It is an unfortunate truth of thank you, feminist and equality seeking litigation. That any win attracts a backlash, and that no win can be taken for granted as something that can be built upon. And I say that like I'm okay with that, I'm really not. And yet here we all are in this room carrying on. And there's something truly wonderful about that. I want to acknowledge.
Hi, I'll try and speak a bit too. Dr. Emma, this was extremely an awesome talk. Like it really touched so many points of work experience. My name is Shanaz Rahman. I'm the executive director at Surrey Women's Center. But I spent 9 years at Bristol Sleep, and a lot of my passion is with family law. We were involved about 12 years back in a study that we did with support from Donna, Margaret, and so many others in this room on troubling assessments. So the piece that you spoke about, you know, the expert witness and how without scrutiny, it just really hit, so many connections for me in speaking to so many women whose lives are defined by this, these assessments and reports. So I just so appreciate the work and the research what you've done in this area and framing all these thoughts so powerfully and strong. So thank you so much.
Belbeer, do you want to test this?
Oh, I can just talk.
So the one.
Just talk.
Just talk.
Oh, okay. All right, if this is online. Well, thank you, first of all, for a wonderful presentation, just synthesizing all the documents that exist. My question is more for us in academia and how we contribute to stereotypes. Because we give out averages all the time, and then they get used and applied to every single case. So how do we put out information so stereotypes don't occur? Because I think we're partially responsible for what happens.
Yeah. I couldn't agree with you more. Academia is so unreflective about its role in sustaining power. And I don't pretend to have all the answers, but what I guess I can share is what I've tried to do and how I've tried to navigate those challenges. From my perspective, the tremendous privilege I have as a tenured academic, with a salary I can rely on receiving, means that I spend as much of my research time as possible doing work that can serve people like Rise and West Coast Living, and the Institute for the Advancement of Aboriginal Women and others. To be aware of the privilege we do have as academics, to try to hold the door open for others, and to care less about H indexes than about whether your work is helping to make a difference. I'm sorry, I don't have better answers than that.
So one of the things that I think is important is our understanding of what cultural safety and humility is about. Because if we teach people that averages are things that you ask questions from, it is not meant to apply to any single situation. And I think you have to put that out in all our studies, because otherwise the whole cycle is going to keep continuing. And we're going to keep saying, oh, well, racial profile is a great example of using averages. And so you go around and, you know, you're pinpointing everyone, oh, this is what they're like. So that's what I try to teach, because I teach cultural safety and humility, is try to get people to see the spectrum and not just the average.
Thank you for, and that actually clarifies the question, your original question a little bit for me. I'm sorry, I misunderstood a bit in that beginning. The debate that has run through criminal law and family law about psychometric testing, for example, I think risk profiling, is exactly what you're describing. And one of the big takeouts from the Psychology Association's response to the TRC report and the Hewitt decision in 2018 is the extent to which, for example, academic psychology as a profession had not thought about the cultural bias within standardized testing, which honestly, I mean, I say this, you know, from the bastion of the most conservative discipline of all, that exercises kind of in some ways the most egregious power. I was surprised that it was not already an active debate in psychology at the point at which that started. But you're absolutely right that if we're graduating psychologists and social workers and lawyers who've never been exposed to these questions, then they will use these risk assessment instruments without thinking about their limitations. And we will continue to replicate the patterns of harm and of exclusion that we have seen.
We're standing up, but should I don't stand up. If I'm sitting and people can hear me okay? Yeah. Thank you so much for your presentation. I really appreciate it. And stereotypes sadly I think if you've worked in the anti-violence field for a very long time, you are very aware of how entrenched those are in our societies and our culture and our systems. My name is Wendy, I'm with the EBC with Kate and Kieran who's here. And I guess when you were talking, it really made me think we're on a couple different initiatives. One of them is the sexual assault review teams that the RCMP implemented after the Unfounded study to look at how police are completing their investigations, and obviously not well. And all of the biases are really entrenched in their investigations. And then we support another initiative in BC, which is interagency case assessment teams, which are working around community on highest risk of partner violence files. And there's over 50 of them in the province. And what we see just through these two different initiatives and the other work we do is that there's so many people working in kind of frontline roles, operational in community with survivors. And they have those missed stereotypes, biases, racism, sexism entrenched into the way they view the people they're working with. And as a result, that gets sort of filtered into their investigation. And then many things don't ever go into court. It's already been filtered in the way that means that now the survivor will have trouble in the family court because probably it's been laid down for her police investigation and it won't go to charges because it's already been entrenched in the system in such a negative way. And I know we're all always working to challenge that, but I guess we struggle with that so much because we're always trying to help communities resolve these issues that they see these things, particularly with police. Because police, regardless of if they know anything about gender-based violence, they feel a massive amount of work. And a lot of the anti-violence programs we work with are always struggling up against that as having the expertise and having the RCMP usually not honoring that expertise. And of course, that impacts kind of the survivors in a meaningful way. So I don't know if I'm asking you a question. I guess I'm hoping you can offer. I know we're all working on these issues together, too, but it's just something we struggle with so much. And it's always just trying to get people to just understand intimate partner violence and sexual violence in a way that the way you're recording it, documenting it, investigating it has a huge impact, and it translates that survivor story is now being translated inaccurately into all these other places, right?
Yeah, thank you for sharing your experience and for the work you do. It's tremendously important. The Mass Casualty Commission looked closely at these problems and heard extensively from frontline anti-violence workers, as well as from frontline police officers. The central philosophy of the Mass Casualty Commission's final report is that funding, that the expertise of anti-violence workers and community workers should be recognised and funded as core in the same way as policing is seen as core and funded. And that the primary response and the primary work of anti-violence and of responding to victims of violence should be shifted to the place where the expertise is, and that's just not policing. And the Commission also made a series of recommendations about improving basic training for police. 6 months is just clearly, obviously, not enough to give a young or even a quite old person, a police recruit, the tools necessary to deal well with patterns of coercive control, with gender-based violence of somebody who is marginalised and about whom they might hold racist attitudes, for example. Until we do those two things, until we fund the anti-violence sector and the community work sector in ways that value their expertise and allow them to exercise the expertise in ways that make a meaningful difference. And until we frankly recognise that police are probably never going to be the best at this, and actually perhaps we have to reconfigure that role quite a lot, I fear we'll struggle to make progress. I love the independent case review model, and we looked closely at that and absolutely endorsed the opportunities it gives for learning. But the Mass Casualty Commission also documented one of thousands, I'm sure, of cases where a sexual assault complaint had been made by a woman in rural Nova Scotia. She had dealt with 18, if memory serves, RCMP members in the course of the 6 weeks between when she made the complaint, was told there was no criminal basis, was told to get a peace order. The peace order magistrate refused to issue the peace order because it was a criminal issue and the RCMP should deal with it. The RCMP refused again, and she was ultimately murdered by the person who'd sexually assaulted her. And these are the stakes of getting it right. And I know that you work on the front lines of that every day. And so thank you for the work that you're doing to improve. And I hope that the Commission's recommendations will help in that space.
Yes. So,
We do have one question online.
oh, sorry. Yes, of course.
So one of those joining us online says, my concern is how dominant family law bar embraces certain experts and that information then becomes the basis for legal advice, often resulting in survivors being told not to disclose or raise violence. Thoughts?
Yes. Joy.
Yeah. I gave a lecture a couple of weeks ago at UBC in the law school, which was very focused on the question of legal culture. And This comes back to your point about backlash. At present, within the professional norms of the legal profession, it is not seen as an ethical breach to invite factual reasoning based on an appeal to prejudice. Adversarialism is seen as the sacred cow at the heart of how we determine facts, and representing the interests of one clients, even on the basis of appeals to prejudice, continue to be protected as a professional practice. I think that while that remains true, we will struggle to make cultural change at the family law bar or at the criminal defence bar. And so while the changes in doctrine are helpful, I think one of the reasons why they keep being undermined is because there's a failure to flow those ideas through to our professional expectations of competence and of what constitutes ethical behaviour.
Kathy?
Oh, I'm so sorry. One more question, Kathy.
May I pass you the mic? It's work to me.
Okay.
I am so impressed with you. I didn't realize there were some academics that were still true to their spirit, given gifts by their creator, that they can speak the truth and be there to be influence the hearts and minds of people that they're educated. I'm so hopeful that maybe there is real hope out there for Aboriginal people, myself included. I'm a survivor of the residential school, and I worked in the criminal justice system for 25 years, of 40 years of being employed within a very colonial system and survived it. I helped establish the Aboriginal Family Healing Court in Westminster, which really is very limited, and the ministry did not, while other communities were willing to have this kind of process, a project in their communities, it was not allowed because of the costs involved. This is a project, a process after that really encompasses the judiciary, social workers, police, and everybody else that involves themselves in family court. And the process is trying to keep families together and not having kids being taken into care and never returned home. That's my opinion. And it's quite successful because we have our own way of looking at life. And it's not necessarily different from mainstream, but it's a much more hard process and not just analytical stuff from the head. It's marrying really the head and the heart. Because what I've done in my work in the criminal justice system has been always to try to hit the heart and the mind of men and women I work with in the criminal justice. And I've done a lot of work with, I know Donna since 1991, and she's one I've seen where she has that great big deep connection. And I admire people like that. The other one is this other judge that who worked with me and with the Aboriginal Family Healing Court. And it's really a process where we're trying to involve the youth now, not just families, but zero in on the youth that have been in care, making sure that they're in touch with their families, so there's some cultural identity with them and not losing them being ashamed of being Indigenous or Aboriginal, whatever their identity is. It's hard, but it's a healing process. And people don't even know about because it's almost being kept silent. Although there is a little bit of a spiel in the Judge's Provincial Court website, but that Judge Brown, Anya Brown, talks about and describes what it does. But Dr. Cunliffe, you're amazing. You're amazing. I have not heard an academic speak like you do in such a long time that I'm so hopeful. But I'm glad that I was invited by Marguerite and Donna to get to know about FREDA. and all the women that are involved here, keep your hearts together and keep moving forward. Never let the system try to keep you in the colonization state that I've been through in my whole life. Continue to try to decolonize the process that does not work for humanity. Thank you.
Okay, actually. We may, any other questions? I think yes.
I don't think this question has any easy answers, but like, I work for West Coast Leaf. We try to intervene in family law cases before the Supreme Court of Canada, but when you look at the criminal law and how it's developed over time, like so many criminal sexual assault cases go before the Supreme Court of Canada every year. It's a space where interveners are quite welcome, and not just before the Supreme Court of Canada, but like before courts of appeal. But I feel like in the family law space, first of all, you don't see cases go all the way up that often. And second of all, like, and for like good reasons, I think, to a certain extent, you know, I don't think courts of appeal or superior courts necessarily want to see interveners in private litigation. I mean, it definitely adds complexity and cost to these cases. And like, when you think about the family policing context, you know, you've got, yeah, it's quite, there's a private nature to it, I guess. So it's like, what are some strategies that we can think about to kind of like to move this area of law forward the way we see in the criminal law context, or like, are there?
Yeah, thank you. And West Coast Leaf and Rise, thank you for the amazing interveners factum that you wrote in Baron Direct, which is on my list of resources. So thank you for taking the opportunity when it does arise. I've been involved in many of those interventions in criminal law that you allude to, including, for example, Barton. And you're right that the structural nature of the appeal process means that those cases go up more often. The fact that there are judges on the present court who have, I think, an interest in that area of jurisprudence is certainly a help to making progress. And I don't think we really have a particular family law expert or voice on the court at the moment. I stand to be corrected on that. There's people more expert than me on that question. So the opportunities are rarer. But as an evidence person, in fact, I've been shifting my focus of intervention earlier and earlier in the process. And so I'm actually now, in lots of ways, much more interested in working with people on trial records than at the Supreme Court of Canada. Because I've seen too many cases get to the Supreme Court of Canada and fail because of the lack of a factual record. And so I think one opportunity for intervention is to work at that trial level on building the kind of record that allows change to happen if a case moves up. Now, in some ways it's more inefficient because few cases move up, but it feels to me like one possible way forward.
Do you mean behind the scenes?
To a certain extent, potentially, depending on what your funding permits. But yes, that is something I've done, is in a couple of cases, work directly with trial counsel.
Thank you. Thank you.